Good morning to all of you. Normally, when a government employee joins the service, he is destined to retire on some date. And normally before 2004, as per the revised pension rules 1980, he can get the so-called pension. After 2004, that system is gone, and now they have got another contributory pension scheme, other things. Now, we know that pension is not a bounty, or it's not just a chocolate given to the audaryam. In Telugu we call it as audaryam. So it's not a bounty. It is a right. So this was once again reiterated by the Honorable High Court of AP in the judgment in the case law relating to SmtG.Madamma, SmtG.Madamma versus Commissioner and another Commissioner 2021. This was the outcome of the WP number 34,552 by 2016, and the judgment was delivered on 12/2/2021. Right? You can refer this case as SmtG.Madamma or Madamma versus Commissioner and others. Now, here I am telling you once again, the two judges bench consisting of judges Honorable Joymala Bagchi and Justice Akula Venkatasesha Sai, they reiterated that pension is not a bounty given by the state to its employees, but it is a right to a superannuated employee, and of course later to his family if the rules permit. So why? Because of the past services rendered. So please remember, pension is not a bounty. He has to get the pension. Why? If it was not given to him or to his family. The dispute is his wife. After his death, his wife wants to get the family pension, but she was not given because of the revised pension rules and other things. Now, we will go through the details of the case. So, the deceased or husband of G.Madamma, by name G. Ramanujanayalu, he worked as a daily wage worker. He joined as a daily wage worker in Kurnool Municipal Corporation in 1996, and he was on the rolls from 1/8/1988. So he daily labor he has joined, but ultimately luckily he was given the scheme as a regularized employee like that from 1/8/1988, right? And of course on 12/6/1998 his services were regularized totally. So as per the record, his services were regularized in 1998, right? So, and they were regularized retrospectively from 1996, right? Now, so he retired and he expired in the year 2012, right? Later, his widow, the petitioner SmtG.Madamma, she applied for the family pension, gratuity and other death benefits as per AP revised pension rules 1980, right? Right. Actually, the municipal corporation also supported her contention, and they have written to the so-called sub-treasury office. But the audit department, actually, they raised objection because the grounds, the defendant was regularized prospectively as per their version. They were regularized prospectively in the category of public health worker in 2008. That is on 12/6/2008, his services were regularized as a public health worker. He joined as NMR. He joined as NMR in 1996. So this is prospectively, right? So since from 2004 onwards, there is no pension scheme, and since he has been regularized in the year 2008, so he cannot get any pension, and his wife is also not entitled for any formal pension as per the revised pension rules 1980. So therefore, her claim has been dismissed by the sub-treasury department, that is Treasury's department. Ultimately, she has gone to the tribunal. She has gone to the AP Administrative Tribunal and filed OA number 2643 by 2015. Of course, there also she could not get any favorable order. Tribunal also said Since your husband's on record, it has been regularized on 12/6/2008. We can't help, no pension can be given. Thereafter, she approached the Honorable High Court. So, please remember, the contention is mainly that the deceased Ramanjanalu along with the 37 other NMRs were regularized in 2008. The government, his advocate says that he was in the pay of the government or municipal corporation right from 1996 itself. Now, the Honorable Court has gone to rule number 13 and 14 of revised pension rules. These two rules are only important for this particular case. Rule 13 says commencement of qualifying service from the date. So this commences from the date he takes charge of the post to which he is first appointed. So he is first appointed as NMR. His services have been regularized in the year 1988. So please remember, so the first charge, so commencement of qualifying service means the date of taking charge of the first post. Rule 14, conditions to which the service are qualified. Service means service under the government. So the employee definitely has got a vested right to pension since he has joined the service in the year 1996 itself. At least from 1998 they have been regularized. So the plaintiff or the petitioner here, yes, the contention of the petitioner was agreed. So, and another point they have given. The petitioner was given a compassionate appointment. So she cannot get the pension like that. But the court did not agree. The court said that the compassionate appointment for the bereaved family, it is only to meet the sudden exigencies arising out of the unfortunate demise of the employee and does not eclipse the right to family pension. That is different. Why you have given the employment? Because suddenly there is nobody to take care of the family. At least some solace should be there. Therefore, you have given the employment. So that employment is not at all connected to the family pension. You have to pay the family pension. Allowed, the writ petition is allowed. And the tribunal order setting aside, the pension orders have been set aside. Now, this is a very good judgment. So, if at all any person of this type comes to your notice, please cite this case law and definitely it will be helpful to you. Thank you very much.